So you're moving in together. Here's our moving in checklist for things that you need to know, do, and why. So first of all, please don't just think about the conveyancing process of buying the home. There are 3 other legal issues for you to consider. The first is making a will. Next, how are you going to own the home together? And finally, whether you should make a cohabitation agreement to regulate the wider financial implications of your relationship. So let's think about a will. First of all, the law says that if an unmarried partner dies, their partner won't inherit any of their estate unless a will has been made specifically making provision for them. So it's really important for you to make a will if you want to leave anything to your partner. Next, think about how you're going to own the property together. If an unmarried couple separate, unlike a divorce, there are very limited legal claims that can be made in England and Wales. Legal claims are based on ownership, so founded in property law and trust law, and can get very complicated. So it's important to clearly define who's intended to own what share of the home from the get-go. Is it going to be owned equally or in different shares? And what will happen if one of the couple passes away? Our advice is always to be clear from the start about who owns what and to record it. That way there's good evidence that can be relied on if there's going to be a future dispute. A declaration of trust can be used to define shares in a property, especially if it's intended for you to own it other than 50-50. Also consider a cohabitation agreement, which can help regulate finances whilst you're together and also help regulate things if you separate. No, unfortunately not. This is a family law myth and is completely untrue. If a couple's married or in a civil partnership, you're entitled to a fair and reasonable financial settlement if the relationship ends. But if you're unmarried, the law's currently limited to making a claim based on property law and trust law. This means that if a house is owned by just one of you, the other might have no claim against it. They might not have a claim against a business if that's owned solely by the other, or their investments or pensions. Neither will they have any entitlement to maintenance other than child support. Sometimes parents can make a claim under Schedule 1 of the Children Act, which provides for some additional financial support to parents for the benefit of children, perhaps to meet needs such as housing. We advise couples to consider a cohabitation agreement at the start of a relationship. It can set out your expectations for how expenses will be shared whilst you're together, and also you can agree how to divide assets and resources if things go wrong and the relationship ends. A cohabitation agreement and a declaration of trust can both be invaluable evidence if there's a dispute, and they can often determine the outcome. In most cases, the engagement ring stays with the person who was given it by their partner. There's no requirement to return a ring unless it was clear that there's an expectation that it would be returned. That might be in certain circumstances, for example, if the wedding's called off or if there's a future divorce. Our advice is always that if the ring is of significant importance to the person giving it, it might be a family heirloom, for example, you need to be clear to your fiancé that you expect the ring to be returned. As ever with the law, if there's a dispute, you need evidence, and so to prove your case, make sure that you have told your fiancé and recorded in writing that you want the ring back before you give it. Prenups are becoming much more common. A prenup is an agreement that a couple enter into before they marry or civilly partner, and it sets out how resources and assets would be split if the relationship ends. A prenup can be used to predetermine the outcome of a divorce settlement, taking away the stress, uncertainty and cost of a court dealing with it if there were a divorce. It's often used as a way to safeguard or ring-fence certain assets to protect them from future claims if there were a divorce, and so is commonly used if there's a wealth imbalance between the parties. Although the law in England and Wales means that a prenup isn't automatically binding on the couple, There are some safeguards you can follow. Provided it's not unfair, it meets both parties' needs and both parties understand what they're getting into, you can expect to be held to its terms, and it should always be signed at least 28 days before your wedding. I hope that you found our checklist helpful. If we can help or you have any questions, please don't hesitate to get in touch.